Let's take this further now with labour lawyer Sherisa Rajah from Fasken Martineau. Sherisa, lovely to have you with us. Thank you so much for coming in today. So let's start off with this issue of labour laws. And one of the claims that Saftu is making is that these labour laws could undermine the right to strike. Is there a chance that could happen?
I would have to disagree with that, because the right to strike is entrenched in the Labour Relations Act. What the labour laws seek to do is call on an individual ballot. So they want the individuals to commit to whether they actually want to strike or not. And the unions opposing this, Saftu and NUMSA, seem to say that, well, in so doing, you're actually taking away the collective power of strike. And we say it's actually not the case. My opinion, personally, is that it actually forces an individual to be held accountable to a lawful strike as opposed to a lawless strike. And when I say that, I mean that so often we've seen in the last, I want to say 5 years, strikes have become completely dysfunctional. They land up in a state of complete lawlessness, and the only consequence thereafter is for the employer to obtain an interdict from the Labour Court and stop the lawlessness, and it ultimately lands up in these employees being dismissed. And we're trying to focus it that strikes are about collective bargaining, it's about mutual interest disputes, and they are perimeters within which we exercise our rights and obligations. So in terms of limiting the right to strike, the labour bills implement 3 things. 1 is the individual ballot. 2 is the advisory arbitration award. Now, the advisory arbitration award forces both parties of the dispute to go to a panel convened by the CCMA to engage on the issues in dispute. The outcome of that will be binding unless it's appealed by either party. And we say, or my opinion again, is that such a course of action actually prevents employees from going into a situation where there's no work, no pay, they deadlock. It lands up in a state of them getting frustrated, wanting to resort in physical violence, intimidation, threats, etc. And ultimately the employer locks them out or calls for a dismissal because they're not willing to come back to work.
So you see this as protecting workers in a certain way?
I would definitely think it protects workers, because often in these situations you have a number of workers who actually want to come to work. They don't necessarily want to participate in the strike. That's the one aspect. The second aspect is often unions get people who are not necessarily part of the employee workforce to come and join the strike to show a strength in numbers. The people that want to come to work, they're fearful for their safety, the safety of their families. They live in communities. And all these measures are in place to protect those that we identify as the most vulnerable in society.
Just explain to me that one of the options here you referred to was an individual ballot. What exactly is that?
So this doesn't exist currently in our law. The intention of the law, the amendment, is to call on an individual ballot where employees who are part of the trade union commit to whether, in fact, they vote on whether they want to participate in the strike or they want a strike at all or not. And I think the opposition view is that the individualization of the right to strike undermines the collective bargaining of the right to strike. But the individual is part of the collective. And if the individual doesn't support, then what exactly is this collective? The other thing is the right to strike, as it sits in the Labour Relations Act, is by no means undermined. In fact, it's protected, because if there's a legitimate issue, the CCMA convening panel will likely find in your favour, and it shortens this long drawn-out strike where you're unpaid for the period in which you're striking into a much shorter period where there's a binding award in your favour. So my personal opinion is I don't see how it can undermine that. The other looming issue is the national minimum wage.
Yes.
And on the national minimum wage, so the way the Basic Conditions of Employment Act works is it regulates a number of issues for employees earning below the earning threshold. Now, that earning threshold is increased from time to time by our Minister of Labour. It currently sits at 172,000 or approximately 17,000 Rand a month. The law identifies that people earning below that don't have or may not likely have the ability to leverage for better conditions of service. But what the law has also lobbied now is this notion that there's an even more vulnerable class below that. Now, those people are the people that we identify as the Bucky Brigade. A contractor needs more hands, pulls up on the side of the road, fills people at the back of his bucky, and off he goes. There's no contracts of employment. You know, one of the opposition articles I read was that the journalist says, well, you know, these employees are now not even going to earn the 3,500 Rand a month. And I say, but they were never going to earn it in the first place. What guarantee or protection do they have that they would have earned that? In enforcement, now instead of going to the Department of Labor on payment of wages, you can go to the CCMA. You get case numbers within maybe a week. You could get heard in a conciliation maybe within 2 to 3 weeks. How is that attacking these people? It's actually protecting them.
So what, in terms of this lexicon that is being used, I mean, the Federation is referring to this minimum wage as an apartheid wage structure.
Yeah.
How do they draw that conclusion?
So they believe that because employees would be earning such a low amount, it's almost equivalent to back in the day where these employees would have been completely disadvantaged, disenfranchised from the ability to ask for more. What the allegation fails to acknowledge or maybe appreciate is these employees don't get more, very likely, in most situations. They'd be lucky or grateful if they got a 30-minute lunch break, as other employees sitting under the contracts of employment and under the BCA would be entitled to get. So for the first time, we've got these potentially Bakkie Brigade employees that are able to say, sorry, I'm not willing to work for less than 20 Rand an hour because the law tells me that.
Very interesting indeed. Thank you so much for coming through to unpack
Thank you for having
us.
me.
Lovely to have you, Labour lawyer Sherisa Rajah, joining us there to discuss the Saftu strike and issues that have been put forward there.